Ms. Briggs.
Thank you very much, my Lord. Shortly before the lunch adjournment, my Lord, Mr Lord Justice Foxton asked a question about sharers and immunity. That helpfully, returning to my structure that I'd outlined at the beginning, what I plan to do now is to address essentially concerns that were raised in the two judgments of my Lord Mr Justice Fancourt and Mr Justice Edward Johnson, and one of those points relates to statutory immunity. So what I propose to do is to incorporate my considered response now into that. So it's convenient in our submission to consider those two judgments together because there is some degree of overlap in terms of the reasoning as to why it was said below that paragraph 12.1 doesn't do what On Tower says it does. There are 5 points identified between those two judgments. The first of them I don't propose to address in any detail because that was essentially the argument that all it's concerned with is terms and conditions, and I've already addressed you on that, my lords. The second one is the one that relates to statutory immunity. I'm at paragraph 109 of my Lord Mr Justice Fancourt's decision, which is page 106, I believe, of the core bundle. Oh, apologies, yes, tab 6. At paragraph 109, my Lord Mr Justice Fancourt concluded that the purpose of paragraph 12.1 is explicable by reference to subparagraph 2 immediately below, which confers a statutory immunity on operators. His Lordship explained that an operator will only have the benefit of that statutory immunity if the right is exercised in accordance with its terms. That is an argument that was advanced yesterday by APW. However, and with respect, it's On Tower's position that that reasoning is flawed. In the first case, as I've already explained, paragraph 12.1 of the code was preceded by paragraph 2.5 of the old code, which we looked at earlier. As Mr Watkin acknowledged yesterday, paragraph 2 of the old code is silent as to statutory immunity. It says nothing about it at all. And that's because the provisions as to statutory immunity were found elsewhere in the old code. Those paragraphs, that's paragraph 4.1 of the old code, which is bundle 2, tab 20, page 502. It's On Tower's position, my lords, that paragraph 2.5 of the old code must have had some independent existence. The fact that Parliament chose, in enacting a new code, to put these two provisions, the statutory successor to 2.5 and the statutory successor to 4.1, next to each other, cannot change that fact, and it can't be used as an aid to the construction of 2.5. We say that that's simply a matter of coincidence, or nothing can be read into it. We would also note that, and this is something that my Lord Mr Justice Fancourt noted in his own judgment, paragraph 12 is not headed statutory immunity. It has a much more general heading, namely exercise of code rights. If this were only concerned with statutory immunity, you might have expected that to be the heading. Mr Watkins sought to suggest yesterday in the course of argument that paragraph 12.1 was somehow tucked away, and it would be surprising the effect contended for by On Tower because of that fact. We simply don't accept that proposition. Paragraph 12.1 appears very shortly after paragraph 10, which we say does the corresponding function in relation to site providers. I said at the outset that I would come back to the point about sharers, and essentially the answer to the question that was posed, a very sensible one, my lord, is we say that the concern about whether or not sharers have the benefit of the statutory immunity, we say that problem only, or that potential question, only arises if one reads subparagraphs 1 and 2 of paragraph 12 as going together and forming a coherent scheme, in the sense that you only get that statutory immunity if subparagraph 1 is understood as saying you have to comply with the terms and conditions. We say everyone has to comply with the terms and conditions, whether that's simply because as the code operator who has the benefit of the agreement, that's all you have. That means you can only share that with someone else. It's inherently baked into the right, if I might put it that way. We say that you don't need to read those two subparagraphs together. And when you look at the wording of paragraph 12.2, you see that it's anything done in the exercise of a code right by an operator. And we say that's wide enough to confer that statutory immunity on site sharers. And that doesn't call into question our interpretation of subparagraph 1. Thank you. So that was one of the criticisms, in effect, that was identified of paragraph 12.1 and our interpretation of it by my Lord Mr Justice Fancourt. Both of their lordships also expressed the view that if On Tower's interpretation of paragraph 12.1 was correct, then it would be difficult to see the point of paragraph 16.4, and that's a point that was also picked up by APW during the course of submissions yesterday. In terms of the references, more so for your note rather than to take you there now, my lords, Mr Justice Fancourt dealt with paragraphs 111 and 112 of his judgment, which is page 106 of the core bundle, which is behind tab 6. That's the page that we were just looking at a moment ago. And my Lord, Mr Justice Edward Johnson, dealt with it at 215 of his judgment, which is Authorities Bundle 2, rather than Core Bundle, tab 13, page 350. I'm conscious, my lords, that we spent some time looking at paragraph 16 yesterday, and it's also been addressed this morning by Mr Lees. But I would be very grateful if you could turn up page 393 of the Authorities Bundle, which is Bundle 2, tab 14. My lords, paragraph 16 is a self-contained statutory scheme which imposes the right on operators to assign the code agreement, irrespective of what the alienation provisions in the agreement actually say. So, take the example of a code license. Even if it says that the agreement can't be assigned absolutely, or if it says that it can only be assigned in return for payment of a fee, then paragraph 16.1 nevertheless overrides the party's freedom of contract and confers upon the operator the right to assign. We then see further down, so that's subparagraph 1, and then we see further down, subparagraph 5 creates a mechanism for an assignor operator to be relieved of all liability for future breaches. That's conditional notice being given, whether by the assignee or the assignor. And On Tower say that in that way it's redolent of section 3 of the 1995 Act. It's a very similar statutory scheme to that set out in the Covenants Act, which, for your note, that's bundle 2 of authorities, behind tab 22, and it's page 563. In On Tower's submission, this is the context in which paragraph 16.4 falls to be understood. It's concerned with fixing the time at which the assignee becomes liable, and it's making clear that the assignee is liable as from the moment of assignment. We say that clarification is necessary, not because it is spelling out the obvious, but because it avoids questions when one reads subparagraph 4 together with subparagraph 5, questions as to whether, for example, the assignee's liability only commences once notice has been given that there has been an assignment, whether it coincides in effect with the assignor's liability, or whether there is a period of time which they are jointly and severally liable prior to that notice being given. We say that's the effect of 16.4. It has an independent existence and is not merely replicating paragraph 12.1 of the code. On a number of occasions yesterday during argument, it was argued on behalf of APW that Parliament, or rather the point was made, that Parliament sought to, or rather chose to disapply paragraph 16.4 in respect of subsisting agreements, such as those under consideration before you now, my lords. We say that paints a somewhat incomplete picture, insofar as it suggests that subparagraph 4 was singled out for individual attention. Rather, Parliament chose to disapply paragraph 16 in its entirety in respect of subsisting agreements. And we say that makes complete sense when one considers the statutory context and the purpose of this paragraph. Because when one understands that paragraph 16 is principally directed at doing two different things, the first of which is overriding the contractual alienation provisions that the parties have agreed to, and secondly, relieving the assignor of liability, one understands why you would be concerned to ensure that that doesn't have retrospective effect, and that only affects the position going forwards. We see that, and I'll come to the Law Commissioner's report in just a moment, we see that from the Law Commission's concern about not interfering with bargains that have been struck, negotiated and priced on the basis of the status quo as is. That takes me neatly onto the Law Commission's recommendations. This was a point that was identified specifically by my Lord Mr Justice Edwin Johnson, who expressed the view that the Law Commission's recommendations of what eventually became paragraph 16, bearing in mind Mr Lee's point earlier, there was no draft bill that the Law Commission was dealing with, were relevant. And in particular, I have in mind the conclusion, as paragraph 220 of his Lordship's judgment, which is page 351 of the authority bundle, which is bundle 2, tab 13. We see there the statement from his Lordship that this recommendation, a reference to paragraph 322 of the report, which I'll return in just a moment, is clearly inconsistent with the suggestion that the burden of code rights was fully capable of assignment by an operator under the old code. His Lordship was considering both 2.5 of the old code and 12.1 of the code, as Mr Morgan said yesterday. However, it's On Tower's submission, respectful submission, that there is no such inconsistency to be found in the Law Commission's recommendations. As I've said, one of the limiting factors in terms of the utility of the report as made to construction is that we don't have a draft bill, and so what we've got to look at is the recommendations and then map that onto paragraph 16 as it came to be. As Mr Lees has already pointed out, the Law Commission was expressly only looking at matters prospectively. It wasn't turning its mind towards what was happening currently, save insofar as that's what consultees were being asked about, and it wasn't considering the position of what was going to happen with these subsisting agreements going forward once the new code came into effect. With those caveats in mind, if I could please ask you to turn to the second authority bundle, tab 19, page 485. My Lords, I'm looking at the section headed the assignment of code rights, which starts at paragraph 3.4. And I'd like to start by drawing your Lordship's attention, in particular, to paragraph 3.6, which is at the bottom of that page. Your Lordships will see there, and I would invite you to read this paragraph in full, but you'll see that the concern that was identified there was that operators wish to share equipment and assign code rights without having to seek the permission of the site provider and without having to pay more. In On Tower's submission, the Law Commission goes on in the very next breath, the next clause, to explain that contractual terms often prevent assignment and sharing without the permission of the site provider, which is generally given only for consideration. And so immediately one sees in our submission the problem that's being zeroed in on by the Law Commission is the problem of contractual alienation provisions. The problem is not whether code agreements can, in fact, or as a matter of principle, be assigned. If anything, the Law Commission appears to be proceeding on the assumption that assignment would be possible were it not for the limitations imposed by those agreements. And one sees the same thing over the page at paragraph 3.8. And if I could just ask you, my Lords, to read the first sentence, and noting in particular the words in parentheses. it's On Tower's submission that what the Law Commission was asking about and what it was concerned with was not whether operators needed to be able to assign code rights as a matter of law. The question was whether they should be given, quote unquote, a general right to do so. Yesterday, APW sought to rely on paragraph 322 of the Law Commission's report, which we just saw a moment ago in the context of my Lord Mr Justice Edwin Johnson's judgment. In their supplementary, the full text of it was set out in my Lord's judgment. The APW have sought in their supplementary skeleton to rely only on the first half of that paragraph. It can be found a couple of pages further on. It appears at page 489 of the authorities bundle, still within that same tab. The full text of that paragraph is that the revised code will need to make specific provisions as regards the assignment of other agreements conferring code rights in order effectively to pass on the burden to the assignee. For example, the code operator to whom a way leave is assigned should be responsible for the payment of rent for the period after the assignment, not the assignor. Now, APW rely on this wording to say that the Law Commission was recognising that some mechanism was needed in order to bind assignee operators, and so they say, they extrapolate from that paragraph 2.5 of the old code, which of course became 12.1 of the new, could not have been fulfilling that function already. However, in our submission, my lords, when one looks at the second half of that paragraph, it's clear that the concern is not with binding assignee operators as such, but with ensuring that the assignor ceases to be so bound. We say that properly understood, and one can see this even when one looks at the first sentence, when one looks at the words effectively and pass, that the Law Commission's concern was ensuring that assignees would assume the burden in place of the assignor, rather than one ending up with a position in which the assignee and assignor were jointly and severally liable. And if I could just ask you, my lords, to flip over the page 490 of the authorities bundle, you see in there the text in bold. Those were the specific recommendations made by the Law Commission, and what eventually became, obviously slightly modified, paragraph 16 of the new code. In On Tower's submission, it's crystal clear when one looks at these actual recommendations that were made, and I would invite you to read them in full at some point, you'll see in particular that one recommendation is conspicuously absent from that list of 4. In particular, there is no recommendation that an assignee operator should be bound by the terms of the agreement as from the date of assignment. Rather, it's clear from paragraph 326 that the recommendation was much more limited in its scope and reflects the points I've just made, my lords. The recommendation was that the assignor should be relieved from liability. In On Tower's submission, this presupposes, as I've already said, that the assignee would already be liable and no separate new mechanism was needed to be enacted in the new code. That's everything I have to say about the Law Commission. I just have one very minor point to make about the judgment of my Lord Mr Justice Edwin Johnson, and then I will hand back to Mr Lees unless I can be of further assistance to you, my lords. There was one final point that was made about paragraph 2.5 of the code by his lordship. His lordship placed emphasis on the second clause, paragraph 2.5, and when we were looking at the old code earlier, my lords, I pointed out that the first half of it is broadly similar, save from some additional words in parentheses, whereas the second section, we don't find that replicated in the new code. His lordship said that paragraph 2.5 wasn't concerned with the transmission of burden, but rather in a situation where a person is bound by a code right, for whatever reason, that person has the benefit of the terms on which the code right was granted. And that's 214, paragraph 214, on page 349 of the authority bundle, which remains in tab 13 in bundle 2. We've addressed this in our skeleton, and I can address it very briefly, hopefully. It's to say that that concern that was raised by my Lord Mr Justice Edwin Johnson, it doesn't address at all what the first half of paragraph 2.5 of the old code is doing. It places an undue emphasis, in my respectful submission, on the second half, and that cannot be the answer to why the interpretation contended for by On Tower should be dismissed. Unless I can be of any further assistance, That concludes my submissions on paragraph 12.
No, thank you very much,
Thank
Mr.
you very
Lees.
much.
Mr. Lees.
Deal with the logistics for one moment. My Lord, just before I move on to the final argument, I gave you a reference earlier to Compton Beecham and said at paragraph 115, I think, and then some others. Just so your Lordships can locate that, that's in Authorities Bundle 1, tab 10, page 236. That'll take your Lordship to the relevant paragraph, and then a few pages behind will be the other reference I gave you. My Lord, my learned friend Mr. Watkin was correct to say that this last argument is of a slightly confined nature. He was slightly wrong to say that it's entirely unique. That's not right. It was referred to, one can see that from, I think, either the skeleton or written submissions below, and in particular for Mr Justice Fancourt. But it is right to say that it is of a slightly confined nature. What we're not seeking to do by this argument, I should say, is breathe life into the pure principle of benefit and burden. Fun though that would be, I'm sure, to make that submission, that's not what we're seeking to do. There are two related, I say rules, they are effectively exceptions to the general rule when it comes to the law of contract and law of licenses, as you'll be aware. There's a close proximity between the two of them, I would say. One is the conditional benefit principle, which is where one has an obligation, a benefit, but that benefit is expressed to be conditional upon. A classic example of that has always been taken to be the context of rights of way, for example, in the case of Brazil. The second is the principle of mutual benefit and burden. That's the principle which originally was, in its purest sense, expansive and would have resulted, I think it's fair to say, in any burdens passing on any contract if you took the benefit. But it remains, as I think is common ground, in a limited sense, and that's where there's a sufficient connection between them, where they're intrinsic, then those burdens do pass. We have there's a helpful summary. I'm not proposing to take your Lordships to it because I suspect your Lordships are somewhat familiar, but there's a helpful summary in Chitty, which starts at it's paragraph 23-082, and that's in the Authorities Bundle 2 at page 568 to 569.
So just turn that off.
My Lord, of course we can. That is behind tab 24, so it's right at the back of the second Authorities Bundle. It's fair to say, if one were to start on page 568, at paragraph 2380, one sees a general description of the principles of benefit and burden. The next paragraph deals with conditional benefits, and then it's 23082 that describes the pure benefit principle and how it's been, to some extent, rolled back. So I propose those simply, I'll give those simply as a suggestion of helpful reminder and aid memoir as to what one is dealing with.
And should we read it or not really?
My Lord, I don't think you need to read it now, certainly.
Okay.
In the interest of time, I won't invite you to do so. But my Lord, what I would suggest is, although they are related principles, it's fair to say sometimes they are either allied together or it's quite difficult to make a distinction between them. Can I take your Lordships to, in Authorities Bundle 1, tab 5, the decision of Davis and Jones? Decision of this court, consisting of the Chancellor, Lord Justice Scott Baker and Mr Justice Lewis, as he was. If we could go, please, to page 111. One starts at paragraph, perhaps paragraph 22. 22 is where one sets out at the outset the pure principle of mutual benefit and burden, and then explains that in Rowan Stevens that was disapproved of and unrestricted. There is a helpful, again, for these purposes I'm going to perhaps fast forward, but I would encourage your Lordships to look at between paragraphs 22 all the way to 27, but the conclusions are listed at paragraph 27, and I might suggest that we at least start there. So what the distillation of the Chancellor in this judgment of paragraph 27 of what, and in particular this is what remains of the mutual benefit and burden principle, not in its pure form, is this. Firstly, the benefit and burden must be conferred in the same transaction. Fine, that's relatively straightforward. Secondly, the receipt or enjoyment of the benefit must be relevant to the imposition of the burden, in the sense that the former must be conditional or reciprocal to the latter. That, I may suggest, might be where there's scope for a difference between the two principles. One is it's conditional simply upon, that can be either, or if it's reciprocal to then that might be in the limited mutual benefit and burden principle, but not the conditional principle. As I say, they are closely related. Whether that requirement is satisfied is a question of construction of the deeds or other documents where the question arises. In the case of land or terms of the transaction, if not reduced to writing in other cases. Your Lordship would be familiar with why it would be that it couldn't be all if it concerned land. In each case, it will depend on the express terms of the transaction and any implications to be derived from them. Then the third principle or part that applies is that the person on whom the burden is alleged to have had them imposed has to have the opportunity of rejecting or disclaiming that benefit. So it's an opportunity to do that. Now, my Lords, if we could just turn back a page to 113, please. We are within paragraph 24 at the top. Right at the top, His Lordship notes that, in my judgment, it cannot be sufficient for the taking of an incidental benefit should enable the enforcement of the burden against a person who is not himself covenanted to undertake the particular burden. So it can't be incidental, that's clear. And that point is, that in fact is taken from a quotation of Lord Justice Peter Gibson in the Thamesmead case, as you would see over the page, but His Lordship summarises the position underneath the quotation. He says, thus, Lord Justice Peter Gibson also stressed the need for a correlation between the burden and the benefit of the successor and title has chosen to take, and his ability to choose whether or not to take the benefit. His Lordship then goes on, as you will see through paragraphs 25, but in particular 26, to refer to two cases, effectively as examples. In paragraph 26, His Lordship refers to the Baybuck case that we have referred to in our skeleton. For the avoidance of doubt, no one's suggesting this part of the judgment wasn't over. So that was plainly the case, as my learned friend says in the supplemental skeleton. The point is simply that this is a judgment, one of two that the Court of Appeal are holding up as an example of how the principle may work. And in the Baybuck case, that involved the taking of the benefit of licences for the income stream. It was the purchase of that. And obviously then correlating burdens. That's explained by His Lordship at the second half of paragraph 26. And we would make 2 or 3 points, just in response to the decisions. It's right to say Mr Justice Fancourt rejected this argument, as Lincoln showed you, and indeed it was also addressed in what we used to call the P1 decision. Mr Justice Edwin Johnson's decision as well addressed it to an extent. But we say there's a couple of points that were either overlooked or were insufficiently considered, and they are these. Firstly, we say even if paragraph 12 doesn't do the magic that my learned friend Ms Briggs has just explained, we say it does. Even if it doesn't have that effect, it nonetheless shows you what is intrinsic, as it were. It nonetheless tells you what is. Even if my learned friends are correct, by which I mean Mr Watkin is correct that paragraph 12 can't do that, it's really just explaining that there are limitations within the right, or there are particular things that go with the right. We say, well, paragraph 12 is here a helpful pointer as to the extent paragraph 12 would identify those burdens, or those limitations, or the conditions for establishing it, then to that extent, that gives you that nexus, as it were, or that causal link of making it sufficiently intrinsic, as is required by the judgment of the Chancellor in Davis and Jones. The word used, I should say, in the Badana case was, I think, intrinsic at paragraph 117. The Badana case is at tab 7. We might look at that in a minute. But
so it doesn't come about from the drafting of the agreement, but just simply by force of that one paragraph in the statute.
Well, my lord, we would say, we might say...
Sounds slightly surprising.
But we might say both, my lord. The point I would make, so the reason as you'll appreciate, I started that submission by saying points that may have been insufficiently...
I mean, it sounds like the paragraph 12 argument dressed up a slightly different way.
Well, my lord, Mr Justice Fancourt also thought the same, and I decided that was my inability to explain it sufficiently below, so I'll try again to do a better job this time. The reason there's a distinction, if I may, is this. It's possible for your lordships to conclude that paragraph 12, I mean, we say that would be wrong, of course, but it's possible for your lordships to conclude paragraph 12 doesn't have the statutory imprinting insofar as it doesn't actually itself impose the obligations itself. It's not changing the position, or to adopt the language of my Lord Justice Foxton from yesterday, it's not changing or overriding the law of contract in that sense, but nonetheless to take from it an indicator which is additional to the wording of the contract itself, that there are rights which, forgive me, there are obligations.
It's not just an indicator, you're actually making it something sufficient, irrespective of the drafting of the agreement.
Yes, but the difference, my lord, would be it is not seeking to impose an obligation that wouldn't pass under contract law. It's simply ensuring that those obligations do pass under contract law. That's the distinction. It may be a fine one, but it is, in my submission, a sound one.
It could be, I suppose, that both para 12 and this principle depend upon the construction of the contract.
My lord, yes.
Exactly the same way.
That would be a possibility, of course. If your lordship's not with us on paragraph 12, as articulated by my learned friend, then I accept, to some extent, then it results in the same question being posed. That's correct. I suppose that where my learned friend is correct, I think he used the word cute below, but not yesterday, possibly with a difference in court in mind, but where this argument is potentially a cute one, and I accept that, is what we're saying, and this is the second point I was going to come on to, is that we say there's nothing in GenComp that specifically says it has to be all of the burdens. Now, I've addressed you on GenComp in detail. My learned friend says, well, it says the burden of the agreement, that assumes all of them. We say this point wasn't considered in full because it was a leasehold context where, with the exception of personal covenants, they're inseparable anyway, so the question doesn't arise. And so we say that an interpretation of GenCom that is open to your lordships is to interpret that if there needs to be some burden, it's only those burdens sufficiently intrinsically linked. And if that is right, then I don't think my learned friend disagrees that to the extent any burdens are sufficiently intrinsically linked, then they would pass under the principle. The reason it's a cute argument is, of course, my learned friend says, well, it doesn't really matter what they are, I don't have to point out what they are, and in one sense that's correct. If I'm right about what GenComp says, then of course that's correct.
It becomes quite tokenistic at that point, doesn't it?
Well, it may do. It may not be, of course, because on any individual agreement,
for it.
The requirement for it becomes slightly tokenistic. I accept that, but as for the effect of it, it might be perfectly powerful indeed. So, my lord, it's a short point, or it has become a short point, and refined all the time. But we say it's not to be overlooked because what it does allow is that in asking what it is that the Court of Appeal, if your lordships conclude it needed burden, if your lordships conclude Mr Justice Fancourt is wrong in his interpretation, and we are wrong about paragraph 12, it is a potential other route for which your lordships could be satisfied that what needs to pass would pass, limited though that could be in any individual case. I don't propose to go through the individual agreements and play individual clauses or rights and say this code rights sufficiently tied to that, etc. Not least because we're quite happy for any of the burden to pass, and of course that's not the question your lordships would actually have to answer. If we're right in this argument, your lordships don't need to identify what that burden is because this isn't an enforcement case. If I'm wrong in this argument, then the question doesn't arise. So I don't think in my respectful submission that would be a particularly good use of time. My lord, otherwise our skeleton argument sets this out in short but fuller detail in the core bundle tab 4 page 77. I simply would refer, it's starting at paragraph 86. I'm very happy to take your lordship to and through, but essentially it's the same point, just put in a slightly different order in a slightly different way. But unless I can give any further assistance on that point, the argument is confined and narrow, but nonetheless stands in my submission to be decided. And it's fair to say in my submission that, although I made, for example, paragraph 12 point to Mr Justice Fancourt, he doesn't directly address that. He's dismissing the paragraph 12 argument rather than dismissing what in any effect it has. Other than that, my lords, unless I can be of any further assistance, were there any questions arising from what I said before lunch? I'm conscious there wasn't much of an opportunity for that.
No, I think we're content. Thank you very much.
Thank you, my lord.
Mr. Watson.
My lord, I wonder if I might just have a moment to rearrange myself and recover a lectern, for example. But
Absolutely.
Is there a lectern sharing agreement?
there is. And it operates, as your lordship will soon discover, in the way that some can, as a blue-on-blue agreement in this case.
Yes. But no one knows what the burdens are, I'm afraid, my lord.
My lord, can I first of all deal with a couple of points of homework which were left for me? The first one of those, both of them by my Lord Justice Holgate. The first one was the rule in Mull and Garrett, which we have gone away and looked at. My Lord is, of course, completely correct that in the context of landlord and tenant, of course, yes, in the context of landlord and tenant, Mull and Garrett is considered the root authority, although it's not quite, for the proposition that a subsequent assignee of the lease owes an automatic indemnity to the assignor of that lease in relation to that. It's fair to say that the principle upon which that is based is not entirely clear. There are two different threads in relation to it. The one on which it is often cited for it is the wider principle that both parties are therefore liable to the same debt, and if the assignee is not pursued, but the assignor is in relation to that, the assignor would then have an indemnity against the assignee, and that's why Mull and Garrett is cited outside of the context of landlord and tenant, as it has been. The other, it's fair to say that some of the, well, at least one of the judgments, and one of the judgments below, in that case, also refer to the possibility that it's just an implied promise by the assignee that they will indemnify the lessor in relation to that. We are dealing with licenses. And in the context of licenses, we have had as good a look as the time which has been allowed to us has allowed us to do. And that is to consider the books on the assignment of contractual rights, of which there are more than one, and indeed books on licenses to occupy or use land, of which there's at least one, and indeed places like Chitty. And we can find no suggestion that the assignment of a choose an action per se generates an implied promise back up the chain of assignment. It would simply be a matter of the contractual agreements. Now, it may be that there's an authority out there which says that, but conspicuously we haven't managed to find it anywhere. And it's certainly true in relation to the implied promise principle. It seems to have been, even that part of it, seems to be based upon the fact that you are taking over the estate of the previous party. So it's because you are acquiring the estate of the previous party, but of course in the license scenario is not occurring. Now, as I said, it doesn't really matter because the point that I was attempting to make was to deal with my Mr Justice Fancourt's position in relation to the fact that it doesn't matter whether there's a break in assignments. He obviously thought that there could be a break in assignments, and he quite literally wrote the book on assignments in relation to landlord and tenant. So at least I'm reassured in that degree that he didn't think I was barking up the wrong tree. But the real point was to emphasise that that wasn't the basis upon which he was saying that his solution was okay. His solution is apparently indifferent to the question of whether by any route at all, up or down or across, we can enforce the agreement. The second point, which my Lord Justice Holgate asked, and which I did answer, but imperfectly, was what happens when the code right has been granted by someone who is merely the occupier, i.e. a licensee in their own right, and when that license, i.e. the license of the person who granted the code right to occupy the land, is assigned to somebody else in that scenario. I mean, it's possible that this can occur. I have to say that nobody on our side, at least, has ever heard of anything like this occurring. And I pause to perhaps point out this fact. What you may be wondering why the code is so obsessed by occupiers, rather than, for example, people with an interest in land in relation to that. And I think the clue in my submission is actually in the old code, and the fact that whoever drafted this obviously started with the old code, which was their most fundamental mistake in my submission, although not their last. If one takes finds paragraph 2 of the old code, which I'm afraid I didn't write the reference down, it's 496. Now, the first few parts of the new code are condensed into the first half of paragraph 2 of the old code, as it were. And the old code was within the Telecommunications Act 1984, which was part of the privatisation legislation, effectively. So it was creating a regime to diversify things. But at that stage, if one looks at 2.3, 2.2 is a... The Law Commission talks about it in the report and says it's slightly confusing as to exactly what it's trying to doing and in what circumstances. So it's slightly a shame that it was then reenacted in a different form. But 3 is quite useful to notice. If a right falling within subsection 1 above has been conferred by an occupier of any land for the purposes connected with the provision to the occupier from time to time of that land of any electronic communication services. So what it seems to be dealing with is actually the fact that BT is installing people's telephone systems or boxes into their homes and is not to be concerned with the question of whether those people have a right to do so. They'll install it. That gives BT what it needs to do in relation to that. And then immunities are then different subsequently, depending on whether they're freeholder and so on. But I'm not suggesting that these clauses need to be looked at in any case. This is just simply the question of why is it that the occupier seems to be involved in this legislation? It seems to be a hang-up from that, is my guess. It's literally a speculation on the basis of that particular clause. I haven't gone back into the origins of it. But to then turn to my Lord's question in relation to that, if you assume that because paragraph 10 has a gap in it, that the burdens, or indeed the burdens of the code rights, do not pass to the occupier's assignee in that situation. So my Lord pointing out that there is a gap in the transmission when an occupier is replaced by another occupier through the occupational licence having transferred in relation to that. So in that situation, the new occupier, the assignee occupier, does not have the burden of the code agreement in relation to that. Well, the position is similar in many respects in that situation to if the occupier just leaves in that scenario. And it's quite clear, because what you have is an operator who's got whatever they've got, haven't got anyone to enforce it against, as it were. And in that situation, it's not a situation which is dealt with by Part 5. That's a situation where Part 4 is operating. The original operator is still a contractual party to an agreement with someone. The person who's now on the land, take it to be the freeholder, is not a party to that. The code right isn't binding on them at that point. So what can the operator do? Well, one thing one can do is to, if the person who's now in occupation of land is the freeholder, one thing you can do is to bind the freeholder to it, because paragraphs 10.4 and Part 2 allow you to bind somebody else to agreement, but you can only bind someone with an interest in the land. So you wouldn't be able to bind the original occupier, the new occupier, forgive me, the new assignee occupier. But the freeholder could be bound, and it contemplates that may occur, and you would use Part 4. Of course, the operator theoretically still has the code right, but the immunity under paragraph 12.2 is also flawed, because that doesn't bind. 12.2 specifically says, or provisions of paragraph 12.2 specifically say, that the immunity doesn't bind the freeholder who wasn't bound by the agreement either. So they're not immune against the freeholder. And of course, the freeholder, if nothing happens, the freeholder can require the operator to remove the equipment, even though the operator has got a code right, or had one, under the terms of this agreement. If it's still existing, it's certainly contractually still existing. And for that, we looked, I mentioned the effect of paragraph at the part 6, but I didn't really take you to it in any detail, but I probably ought to show precisely how it's engaged by inviting you to look at page 434 behind tab 14 of bundle 2 of the authorities, unless you're using a different form of the code. It's one of the features of code cases that everybody uses their own case and tells each other the code references, the page references, without ever looking at the document which is being referred to. But page 434 is paragraph 37. When does a landowner have the right to require removal? And paragraph 1 simply says there are a number of different circumstances. It has to be one of the conditions has to be satisfied. And the first condition, which is in paragraph 2, so this will work. Another condition would also work. The first condition is that the landowner has never, since the coming into force of this code, been bound by a code right entitling an operator to keep the operators on or over the land. So in the scenario that we've just envisaged, nobody who is engaged here, if the operator might not be, the assignee occupier might not be a landowner for these purposes. If we assume that they're not, the assignee occupier doesn't get to do anything at all, because if they're not a landowner, they can't invoke paragraph 37. But if we take the easier case of the freeholder who's left there, this is what the code envisages. They're someone who was never bound by this. So they use part 6 and serve a notice saying, I require you to leave. Here is a reasonable time within which to leave. And if you don't leave, I'm going to go to court and get an order requiring you to leave. And in that situation, as I pointed out before, the subsequent provisions make clear, and it's actually on page 444, but it's paragraph 48, is that if this matter gets to court, if by that stage the operator has applied for a new code agreement, then the court can't throw them off. And again, that's part 4. So these are all situations where someone who is on the land, the system for the code envisages, and indeed by virtue of part 6 specifically envisages, that notwithstanding that they're here and notwithstanding that they have a code agreement, they will still have to use part 4. Because by definition, 37.2 is by definition talking about a situation where there is a code agreement, but the landowner isn't bound by it. So it's not right to say that in all circumstances where a code operator has an existing agreement which is still running and which gave them code rights, they have to use part 5, because there are circumstances in which they won't be allowed to use part 5. They'll have to use part 4. And my Lord's question has exposed one of those, and I should have explained that by reference to the freeholder, because it's easier. Because the answer is the same for both. So although in Compton Beecham, for example, the Supreme Court has said, if you have a right to use part 5 to renew, you should use part 5 to renew, the code frequently acknowledges the proposition that someone who has a code right may nevertheless end up using part 4, which is what the result would be here if they were left in a position where they couldn't access part 5. I hope that answers my Lord's question, but I'm going to move on unless I'm stopped, even if it doesn't. I will deal with paragraph 12 next, if I may. My learned friend, it may be useful to just find paragraph 12 and have it visible. It's on 388. The purport of one of the strands of argument, as I understand it from On Tower, is 12.1 must be imprinting all of the terms because it's possible for there to be a code right which doesn't have any terms of any kind in relation to it. It's slightly difficult to envisage, and we've already said it's difficult to envisage how something can't have any terms at all, because the code specifically requires you to specify its duration, for example. So even if, as my learned friend points out, the agreement would nevertheless be preserved, it will have had a duration when it was specified. There will have been a term which applied to it. But clearly, it can be perfectly coherently read as meaning a code right will be exercised as only in accordance with the terms subject to which it is conferred, if there are terms. If there are no terms, it will be being exercised in accordance with the terms subject to which it was conferred, because there are no such terms. Then learned friend also refers to paragraph 2.5 of the code and to the different wording and the parenthesis within the wording of 2.5. That is on page 497. Except in accordance with the terms brackets, whether it's to payment or otherwise. My learned friend praised that in aid in saying that the terms to payment, as it were, seems to be redolent of something which isn't a code right, a condition for the exercise of a code right, because that's a rare thing to occur. It's not at all rare, and my learned friend gave you the example of why it's not rare. Code agreements, what has been prohibited by the new code, but what was in existence under the old code, was the ability to specify you can share this site with another operator, but you have to pay us 20% of what you get from the other operator, which is called pay away. My learned friend referred to that. That's one of the things which the new code abolished. So under the new code, you can't have pay away, and under the old code, you could have a term which was subject to an additional payment. And what's the other difference between the two codes? Well, one is the deletion of the reference to a term as to payment. So if anything, what this seems to be doing, the difference in the parenthesis seems to acknowledge the fact that what we were thinking of was conditions as to the exercise of a right which are subject to payments, which is why the parenthesis has been removed. Returning to paragraph 12 itself then, but although it's still true in relation to paragraph 5, a point which is not touched upon by the submissions which have been made on you is another point about the wording of the clause, is it refers to a code right being exercisable only in particular circumstances. And that raises all sorts of difficulties if it's imposing all of the terms. So, for example, what happens if it's not being exercised? So if you've acquired a code right which isn't being exercised, for example, an agreement was created for a site, and before the site is actually engaged with, there's an assignment of the code agreement to another person because there's a delay or something in relation to a rooftop, it doesn't get built for a long time, or I mean, quite often in relation to these things you get a site agreement which is created because another site is disappearing somewhere else, and the transfer of stuff onto the new site occurs once that needs to be done, which might be some time later, who knows when it's going to be. In that situation, is it only when the exercise of the right occurs that suddenly all of the terms are imposed on it in that situation? Or does it, as my learned friend wants to make it do, actually mean a code right that has been conveyed to operator 2, whether or not exercised, means that you are subject to the bundle of all of the rights of the agreement in which that code right was originally created? And what happens in a situation where only one of the code rights has been assigned? For example, or it has been shared. Who is subject to what if every code right suddenly has, as an incidence of it, all of the obligations under the agreement? I've already referred to clause 2.5. My learned friend gave you some detailed submissions to say why the Law Commission's attitude towards clause 2.5 doesn't tell you anything, as it were, and it's all entirely consistent with their case that 2.5 did the same thing as 12.1 did. Various things to point out in relation to that. The first one is that in the passage I've already taken to you, it's paragraph 3.5 within, I won't take it back to it, 3.5 on page 485 of the authorities bundle. The Law Commission explicitly says this makes no provision, i.e. the old code makes no provision for changes in the business entities of the operators. So in terms, it says nothing in the code is attempting to deal with a change of the operator. And that conclusion, that analysis of the code is clearly inconsistent with the suggestion that 2.5 is there specifically to do that.
Just in terms of how this works, obviously the Law Commission probably is not a permissible aid to interpret the old code, but it does precede the enactment of 12.
Correct.
Which you say is intended to replicate the old code, and therefore the Law Commission's view as to the effect of the old code is of assistance when interpreting that similar language in the new code.
Yes, my lord, exactly so. And my learned friend invites you to read paragraph 322 as in a somewhat strange way in my submission. But again, my lord, Mr Justice Edwin Johnson was completely right to say if you fairly read that paragraph is clearly inconsistent with the proposition that there is already an imposition of the terms in relation to this by paragraph 2.5. And that leads us on to the difficulties created by paragraph 16.4 of the new code. That is the clause which does say that from the time when the assignment of an agreement on the part 2 of this code takes effect, the assignee is bound by the terms of the agreement. Well, it still doesn't explain, and no explanation has been given to why 12.1 is there if if it's doing the same thing as 16.4. But not only that, there's no explanation of why, if they're doing the same thing, they're expressed in different terms. And that's very unsatisfactory in relation to the disapplication of 16.4 under Schedule 2. Because not only is it somewhat misleading to disapply 16.4 if there's another provision in relation to it somewhere else, but actually the other provision is differently worded. And that's sort of a different category to the suggestion of odiousness in relation to what we say about what 12.1 is doing. Our case is that if they're right, 12.1 is duplicative of 16.4, except it's worse than that because it's in different terms and it's operating in a strange way because 16.4 is turned off. Their point is that you don't need 12.1 because properly interpreted, the code will mean that anyway, somewhere else, because it goes without saying. Well, the fact that it goes without saying is rather different and has nevertheless been made explicit is rather different to the suggestion that there are two clauses with different wording which are attempting to do the same thing, one of which periodically gets switched off. And the final submission in relation to the final category of submission which was made in relation to this is the purposive approach point. And my learned friend is completely right that at every stage of this litigation, On Tower has made completely clear that if we're wrong about the effect of 12.1, nobody will be more delighted than On Tower because it means that we do have an enforceable agreement against everybody who's a licensee. However, the purpose of approach must have its limits, and effectively choosing to read a provision which is for a different purpose as having a different effect might be stretching it a little bit. With respect, and it's certainly not what was being envisaged by my Lady Rose. Because what she said was, you look at the way the scheme is to operate, and then you accord the word which you're trying to interpret consistently with the way the scheme operates. It wasn't you rewrite the clause in a way to do something which it's not doing. with not using any available meaning which is there. My Lords, that's my submissions on paragraph 12.1. Turning to the central issue, as it were, actually, before I do that, perhaps I'll just deal with my learned friend's benefit and burden argument and come back to part 5. As a useful shorthand into this, perhaps I can take you to back to the judgment of my Lord Mr Justice Fancourt at 107 of the core bundle, behind tab 6. The FTT rejected on Tower's further alternative argument that the burden of the licence agreement passed to it under the principle of benefit and burden.
Sorry, I'm looking in the wrong place. Where
sorry, 113 on page 106. I'm sorry, I must have said the wrong thing. It goes over onto 107, but it's 106. I'm sorry, it begins on 106. So, my Lord's introducing the benefit and burden principle by reference to what the FTT said. I would point out, in relation to the lots of references to the specialist tribunal. Of course, the FTT is a specialist tribunal, but it was only a specialist tribunal in respect of the Telecoms Code when matters were transferred from the Upper Tribunal to the first-tier tribunal, which happened almost immediately before these decisions. So, in fact, this is almost the first decision of the FTT in relation to any principle of interpretation of the code at all. I simply make that remark in passing. It wasn't, they were dealt with by the Upper Tribunal until the Upper Tribunal decided, well, the original plan was that the Upper Tribunal would deal with all the points of principle and then it would be transferred to the first-tier tribunal. Eventually, the Upper Tribunal decided that the points of principle weren't going to stop, so it transferred them to the FTT anyway. It seems to be the implication of them. The first-tier FTT rejected On Tower's further alternative argument that the burden of the licence agreements passed to it under the principle of benefit and burden. On Tower raised the point again in response notice of appeal. It's unnecessary to say anything much about it in view of my conclusion on the first instance. Save it seems to me that the FTT was clearly right to accept the argument of APD that the limited principle of benefit burden has no application to generality of independent obligations on the part of the licensee and licence agreement. And this is the useful shorthand bit. As stated by Beatson, Lord Justice Beatson in Budana and Lee's teaching, citing Professor Tolhurst's book, The Assignment of Contractual Rights, there must be a contractual duty or burden that does not merely define a contractual right, but is inherent or intrinsic in the right itself. Now, defining point, a situation where a right might be defined by the burden, might be your right to payment depending on the way in which your land is being used under a pay-away, for example. In the same case, the burden in question must be relevant to and linked to the exercise of the right in question. So it's not simply, for example, reciprocal rights, like a licence fee or something like that, one of which might be defining the other one. But it has to be intrinsic to the link to the exercise. So the classic example my learned friend says in this scenario is Hansel of Brizell, a situation where you have the right to use sewers and roads, as it were, but you have to contribute to the maintenance of the sewers and roads, otherwise the sewers and roads won't be there for you to be able to use them. It's not simply that there's a reciprocal fee for the ability to do something, because of course that would, and that's the point which is made by my Lady Justice Gloucester in Budana, and I will take you to this, which is page 166 of the First Authorities bundle, that otherwise this simply collapses into a consideration of whether or not there are reciprocal obligations in an agreement. And just to remind you, I did say this yesterday, but the context of this was there had been a transfer of a CFA, well, transfer instructions between two sets of solicitors. So the retainer moved, and the CFA was purported to be transferred as well. And the problem came that if that turned out to be a novation, and there was therefore a new agreement, it would have occurred after the point at which success fees ceased to be recoverable. So the NHS was trying to say we don't have to pay your success fee because there'd been an innovation after the change in legislation. And that was the context of it. And ultimately the conclusion of the court was there had been innovation, but you have to interpret the legislation as to allow that to occur, otherwise it would be terribly unfair. I hope that doesn't do too much injustice to the answer. There's obviously a great deal of careful reasoning. But one of the points which was made was attempted to be made, was that there was an earlier decision of Mrs Justice Rafferty in a case called Jenkins, which has suggested, in effectively addressing a similar problem, that because the CFA was an entitlement to money in relation to doing work, those two things were inextricably linked, and therefore there was a mutual benefit and burden. And if I just invite you to read numeral 4 of her reasons why she disagrees with my lady, Mrs Justice Rafferty.
So this is
sorry, numeral 6, forgive me, on 166.
62.6.
62.6, yes. What we take from that is that it's not necessarily the case that there are any, in a reciprocal contract, any benefits and burdens which would pass under this principle at all. And in fact, most frequently, it will not be the case that there are any at all. So you can't assume that there would be any benefits and burdens which would pass, which is really why my learned friend then falls back on paragraph 12, which I'll come to in a minute. So the answer is either it's paragraph 12 again, as my lord said, this is just a redressed version of the paragraph 12 argument, because all the benefits are attached to all of the burdens, or my learned friend would have to identify for you which are the mutual benefits and burdens which pass, or we're back into the other argument, which is it doesn't matter whether any burdens pass at all. And so we're either in paragraph 12, which I've addressed, or we're in no benefits and burdens, which I will address again in a moment, or there's something in between for which no justification has been put forward at all, and as my lord put it, is somewhat tokenistic at that point. No explanation has been forthcoming as to why that token is helpful or useful or consistent with the policy of the code or anything. So, my lord, that then takes us to part 5, back to part 5 of the code and the difficulty of the central difficulty of the drafting which we're facing. Can I just say this by way of introducing my reply on this point? I think it's clear, I think everybody accepts, that the draftsman anticipated there will be two characteristics of an operator who was party to the agreement. The draftsman was anticipating that that person would be a person who was concerned in the site, and also that person would be subject to the burdens of the site. And we can go back over the provisions to show you that. It is quite obvious in the drafting of those provisions that at various points, my learned friend points to the ones which show concern for a person who's actually interested in the site, and I point to the ones which show concern as to the being burdened by the site. So the question for the court and for all courts below is how can it be made to work in a way which is consistent with that process in some way? Those two assumptions in relation to that. My learned friend's solution only solves one of those, because it simply says it's consistent with one of them and dumps the other one. My lord, Mr Justice Fancourt's solution attempts at least to acknowledge the requirement to satisfy both. And that's the central problem with my learned friend's only benefits scenario, is it doesn't satisfy the central need for both. And just to emphasise the central need for both, and to answer another point, my learned friend has said it, and it's been pointed out before, I think by my Lord Justice Holgate, that paragraph 31 itself doesn't refer to burdens. And it's right to say that its concern is focused on making sure code rights continue. But it does refer to agreements. It doesn't say that the code right continues. It says that the agreement continues, and the agreement contains the burdens. So with respect, although it doesn't explicitly refer to burdens, it does implicitly refer to burdens, and it refers to something which clearly means that it is acting on the burdens. Then the second point, of course, we've already seen it many times, and I'm not going to labour it more than I have to, is paragraph 31(4), the issue in relation to how to read breaches in relation to that. My learned friend gets into great difficulty, but he says that you just remove the reference to the breach of its obligations in order to do that. So you just the breach of obligations generally, but he hasn't addressed, because presumably he had no answer, although he heard me say it, that doesn't solve the situation where nobody has breached an obligation because it's a negative obligation and the original occupier has said, I will not do something, and hasn't done it. And the new occupier has done it, but didn't say I wouldn't do it. So you have to rewrite the bargain in order to achieve that. You have to rewrite the obligations to not allow or cause or suffer to be in all of these situations in order to make it work.
I mean, I suppose because this arises in the context of whether there's a ground rather than because a claim is brought for breach, there might be more scope for asking whether there would be a breach were the obligations to apply, rather than necessarily insisting on there actually being a cause of action.
Yes, it may get quite complicated in situations where you have obligations to stop other people from doing things. For example, it can be quite complicated, but I accept that it would be possible to reframe entirely the obligations, but somehow you're going to have to do a lot of violence to do that. But the reason for really directing my fire on this provision at the moment is simply to illustrate the point that what Parliament is intending is that, or anticipating, is that the person will have the burdens in relation to that.
Yes.
The degree to which one can cause violence to remove that requirement doesn't answer the fact that it's absolutely apparent that Parliament intended that they would have that, or at least anticipated that they would have that. Then perhaps more difficult still is the provisions in relation to modification. Because in the scenario where you don't have to have the burdens in order to be a party to the agreement, you can modify obligations to which you're not party, and the person who is party to those obligations seems to be irrelevant in relation to it. But consider this situation. A site provider, rather than the party who's subject to the terms, a site provider asks for a modification of the terms to add another term in relation to that. Who is that to affect? And how does it do so? So if APW says, well, we want an additional term in relation to this to make sure you're complying with this new bit of legislation in relation to electromagnetic radiation or whatever it is, the court cannot modify the obligation in order to make it applicable to the On Tower, because On Tower is not subject to any of the burdens of the agreement.
So you've got, there you get to a point, do you, where the court, the tribunal has the menu.
Yes.
So could it then say, well, see what you're asking for, not a good idea to have a modification, we'll give you a new agreement instead.
Yes, it could certainly do that. That is a solution to that particular element of that problem. Of course, it won't have dealt with the situation that nobody would have been responsible until then. Neither would it deal with the interim modification problem. So it's not just final modifications, it's interim modifications and interim rents. And in that situation, the court can't do anything to fix it. And as my learned friend was at pains to point out, one of these cases has been running for 6 years. Fair to say that's a pretty unusual scenario, but the point is nevertheless an important one, because in fact the only way a site provider can change anything in relation to the way these sites operate at all is by access to the interim modification provisions in relation to this, after the agreement has passed. The suggestion has been raised by my learned friend that the original parties to the agreement might not be liable for the agreement in relation to this. And his suggestion is that it might not be liable to the agreement because at the point of continuation it hasn't signed up, as it were, to the further term in relation to it. It might fall away at that stage. In my submission, it's very difficult to see how they couldn't be continue to be liable for it in circumstances when it just makes either nobody liable for it because nobody's being bound by their obligations. It's very difficult to see that Parliament is intending the agreement to continue in the sense that you get the code rights but the obligations have fallen away.
So this is a matter of constraint paragraph 30, really.
Yes.
Yeah.
Well, it really takes us to the question of, my learned friend raised it
Yeah.
in order to try and create difficulties in relation to it being weird that people are being concerned in circumstances where they may not have the burdens anymore either contractually in relation to this. But it's difficult to see how the whole thing works in circumstances like that, because you will end up in a situation where nobody has the burdens under that scenario. But equally, what happens if the agreement ran on past its term date with the original operator in place? There are plenty of those around because there are agreements which were being granted right up to the moment when the code was implemented. So in that situation, the code gets continued, someone assigns it afterwards. What's to happen then? It expires, it's continuing, the original operator is definitely liable for the burdens at that point. Do the burdens just fall away when the assignment occurs? And if so, why do they? Why is that person more bound for the first period of their continuation and then not bound for bound after that? My other friend addressed GenComp by saying ultimately that although it says in terms that the regime works, the regime is the term that's used, works on the basis that the party to the agreement is the person pro tem who has all of the benefits and all of the burdens of the agreement. That because it didn't consider this situation, there's nothing useful in it. And because the Law Commission was only considering future assignments, there's nothing useful in that either. With respect, what the analysis in GenComp does is it identifies a number of useful things. Firstly, it identifies the useful concept of standing in the shoes of, and what that actually means. And secondly, it identifies what Parliament must be happy to go on in relation to this, what Parliament must have been anticipating. And I appreciate that it does the second part by reference to what Parliament intended for the future in relation to assignments in relation to that. But what it's saying, and of course GenComp itself is a case of a pre-code agreement. What it's saying is Parliament must be happy for assignments in the future because it's happy that everybody is being properly protected in circumstances where all the benefits and burdens have passed. And of course, this legislation, my learned friend was at pains to read all of the bits about the fact that the legislation is designed to facilitate operators. And of course, it is designed to do that. But what it's actually doing is to balance the rights of operators against the prejudices to the site provider for the public good in that situation. So it would be very strange indeed if Parliament didn't care about the site provider's position in relation to all of this. But what it does is effectively it adopts this principle of the policy of underlying the code being generally in favour of assignments in circumstances where one person stands in the shoes of the other. But it also very carefully, the analysis in GenCom very carefully identifies what standing in the shoes means. And it doesn't mean what my learned friend and my Lord, Mr Justice Fancourt, suggest it means. It's not from the viewpoint of the assignor and assignee, as my Lord Justice Foxton pointed out, as between themselves, whatever's going on, they might be entitled to make themselves bound between each other in any way that they like, regardless of whether it has any effect anywhere else, as it were, contractually speaking. What you do get from GenCom is that when you're trying to identify whether someone is in the shoes of their predecessor, you look at it from the point of view of the other side of the contract. And that is the fundamental distortion of the solution of my Lord Mr Justice Fancourt's solution, because he says in terms that he's looking at it from the point of view of one side of the contract, whereas between the two of them, one has moved into the shoes of the other, in terms of that very, very limited form of responsibility which is created. And that is how we're left with the indemnity provision, the existence or absence of an indemnity provision being the deciding factor between whether or not someone isn't in the party, which is another, in my submission, tokenistic solution. Doesn't actually make any difference, practical difference to anybody, whether that is or is not the case. So how the code can be designed to work in that way is difficult to see. My learned friend says it's benefits of the agreement alone. But if it is benefits, which benefits? Which code rights have to be assigned? Do they all have to be assigned? What if some of the rights are assigned? What if the rights are assigned to different people? All of which is contractually possible. Unless you have a coherency of the fact that you're looking at the bundle, as it were, it starts breaking down very quickly into how on earth this is to work. My learned friend says nothing about that. All of the scenarios which have been gone through are lots of different ways of saying the same point, which is that on APW analysis, at some point the status will change, but until it changes, the status of being the party to the agreement may remain with someone who is not the person you would expect it to be.
How does your unilateral deed solution work if different?
It doesn't.
Right, no.
It doesn't. The party to the agreement remains the party to the agreement until somebody else becomes the party to the agreement.
If you've got different code rights assigned to different people, do they have to undertake the entire set of obligations in the deed in their drawer in order to be a requisite party?
Well, we would say in that situation, if it's not a sharing situation, you're simply, what you're doing is creating a situation which doesn't allow you to renew it. Because you've fragmented the rights into parts, and Part 5 is no longer an apt way of dealing with it. And if you want a new right in that situation, if someone terminates your rights, as we might do, by serving a notice on someone who's no longer interested, and them no longer being interested, the new people can apply for new Part 4 rights.
I mean, I sort of sense that the split rights scenario seems to be so far from the contemplation of whoever drafted this that it actually creates huge problems for anyone's analysis. As far as
well, it doesn't create... the central thesis of our analysis is there really isn't a problem if operators, if you understand the fact that operators all over this code may end up back in Part 4 in particular circumstances. That is just another scenario in which people may end up back in Part 4. The people who don't want to be in Part 4, who want to be in Part 5 in this scenario, are the operators in particular circumstances. We're trying to avoid being in Part 4, want to be in Part 5 in relation to that. But it doesn't actually create any problems at all, operatively, except the exclusion of Part 5 in that situation. And we say the exclusion of Part 5 isn't a problem, because Part 4 is there, and indeed Part 6 is there. And all it's doing is it's creating another scenario, like the scenario I began with, where the code is implicitly contemplating that operators will be pushed back onto part 4. So it creates difficulties in the if part 5 is available to people once you have fragmentation, it's a total mess, I accept. But there's no problem if you take the view that fragmentation is destructive of your ability to use part 5 to get changes in the situation. Once you've fragmented it, you have to start again. So in my submission, my lord, it doesn't actually, it's not a problem on everybody's case.
Well, at least not as much of one.
Well, it's the same problem. If we're right, which is that you have to have all of the benefits and all of the burdens, part 5 is not available if you fragment them. If they're right, and you only have to have the burdens, part 5 is not available if you fragment them, as it were. I accept that point. So the point that I was making a moment ago was that where you end up with is that notice may be served on a surprising person, as it were, in a circumstance where, and that is obviously a situation which the draftsman was not intending. I accept that is one of the two things which the draftsman was contemplating when he drafted it. One of the two was that you would be serving notices on someone who is concerned in the site. I accept that. But in my submission, that's the less destructive thing to try and, of the code, to try and say, well, I'm afraid there will be scenarios where that doesn't work. My Lord Mr Justice Fancourt said it's vanishingly unlikely that, in practical terms, that would create a problem. He said so, and that hasn't been actually challenged before you in relation to that. But in practical terms, that's not a difficulty in relation to it. And it comes with the benefit that, in fact, the site provider will know what the scenario is. We'll know where the benefits and burdens are in relation to that. Unless we get into the scenario of people executing deeds deliberately to try and be destructive of the situation, as it were. If someone says, well, I put a deed in a drawer because I put my finger on it in order to deliver it, and then deliver it to myself by putting it in my drawer, which I accept. I should add, my learned friend's exposition was quite correct in relation to the delivery of deeds. The operators in this scenario, although they have competitive rivalries, are still supposed to operate in accordance with the requirements of their Ofcom licenses in relation to this situation. So I think we can probably discount the fact that the operators, at least, will behave themselves in a way which is obviously destructive of the operation of the code, one would hope. But certainly, whether that's true or not, the code shouldn't be interpreted on the assumption that the operators will act in a way which is disruptive of the operation of the code. But in terms of the scenarios, what we're really talking about is the level of clarities which are provided by the various situations. And of course, my friend referred to the fact that there are hundreds of notices. In fact, there are hundreds of notices even by their clients which have never been acted on, or by predecessors of their clients, which are floating around there, not acted upon, because the courts have taken the view that because there is no specific statement that you have to execute act on a notice within any particular time, they can last forever, effectively, which is itself a grave difficulty, as it were. But in relation to lots of these historic notices, we may never know whether or not there were indemnities earlier on in relation to this situation. And at the moment, we don't know at all whether any of those notices are valid. Not one of them. Because we don't know whether there is an indemnity in any of the people's agreements which caused the person who served that notice on us to be the person who was serving a notice. We simply can't tell. If that person had to have given us a deed identifying themselves as bound by the agreement, then we would be able to tell. My learned friend makes the point that it's hardly a benefit to the site providers, my solution in relation to this, because they could serve a deed of adherence just before they serve a notice in relation to that. Well, of course, it's true that could happen. My Lord provides an elegant solution in relation to that, which is that it may be that the court wants to interpret the agreement to the obligation as being such as to require them to adhere themselves to any previous obligations under the agreement as well to do that. That would be a way of fixing that solution. And if the court wished to interpret it in that way, then of course that would be a way of doing it. But even if my learned friend is right in the extreme situation, it is still of benefit to the site provider in that scenario. Because it will be of benefit to them during the course of the proceedings. From the point where the notice has been served, for example, some of these notices have got 18-month periods in relation to them. They will have the benefit during that. And they also get the benefit at the end of it, even if there's a termination in relation to it, because very often these obligations include the obligations to reinstate the site at the end in some way. So, my lord, I was it may be somewhat dismissive of me to have described my lord's judgment below as being the worst of all possible words in terms of solution, but it is a worse solution because of the intrinsic lack of information. The crucial factor which tells you who the party to the agreement is isn't available to the person who has to know who the party to the agreement is, so it cannot be the right answer. That is apart from the fact that the crucial distinction turns on something which has no effect at all, either in relation to the code or in relation to the site provider. So ultimately we come back to the propositions which I started with, that the draftsman's clearly intended it to be concerned with the person, the operator who's convinced with the site or concerned with the site, and also one who has the burdens. And in my submission, you favour the second one because actually it's consistent with the operation of the clauses, whereas the first one is just an inconvenience for somebody in that situation. It will work perfectly coherently in the way that we say. And there is no risk, and my learned friend made no submissions on the fact that their clients were actually at risk of anything nasty going wrong to the operators in relation to this at all. Rather surprisingly, no submissions were made at all. I gave you I dealt with all of the points in advance where categories of concern or risk have been raised in relation to this, and they're all illusory. And that's, in my submission, made clear by the fact that no submissions have been made to it. My lords, I've tried your patience long enough, and in fact we finished well before 4 o'clock, so your lordship was right to ask how can this last 2.5 days.
Between you all, we are more than half a day ahead, so I'm not complaining.
Well, if we could go on further with the listing office, there's any danger of the listing office giving you more to do tomorrow.
No, thank you very much. So that concludes your submission.
It does, my lord.
Yes, thank you. So you will be staggered to know that we're not going to give judgment here and now. You will receive the draft judgment in the normal way for you to correct our English and typing, but not, of course, so as to give you a chance to re-argue the case. We'd be grateful if at that stage you would also seek to agree an order dealing with consequential matters. If there are points on which you can't agree, could we please have brief written submissions, and we would expect to deal with the points in the order that we make. Lastly, although I know everybody will be very familiar with this, I ought to remind you of the importance attached to the embargo on the draft judgment. It is the case that despite warnings, there are still regularly breaches of the embargo. If you think of anybody who we don't already know about, who you think ought to see the draft judgment, you obviously need to come back to us to get permission rather than sending it to them anyway. But thank you all for very helpful submissions.
Great, my lord.
All rise for April.